Hello from Brexit land. I'm here today to update you on the latest legal and political developments on Brexit, which isn't going to be easy because the position seems to change daily and even the UK government itself seems unsure of the direction of travel. The only thing we can be certain about is that there is no certainty and that this video is likely to be out of date by the time you watch it. In terms of legal developments, we're currently seeing the passage through the House of Lords of the European Union Withdrawal Bill. It's at the committee stage in the House of Lords. The bill itself repeals the European Communities Act 1972. That will have the effect of ending the supremacy of EU law in UK law and ensuring that directly effective UK law will no longer have any effect in the UK. So to avoid the UK falling off a legal precipice on the 29th of March 2019, the bill converts EU law as it stands at the moment of exit into domestic law. That's going to create a novel category of law known as retained EU law. The bill also addresses how retained EU law is to be interpreted and applied by the UK courts from now on. The decisions of the European Court made after exit day will not be binding on UK courts or tribunals. Domestic courts won't be able to refer cases to the European Court after exit day, and they are not going to be required to have regard to anything done by the European Court or any other EU entity after exit day. On the 29th of January, the House of Lords Constitution Committee published its report on the bill. The report is very critical of the bill, describing it as fundamentally flawed from a constitutional perspective in multiple ways. So that's reassuring. In particular, the committee is highly critical of the fact that the bill does not assign a legal status to this new body of law and empowers ministers to determine the legal status of individual pieces of retained EU law. However, the committee has recommended a number of amendments to address the flaws in the bill. Its central recommendation is that retained EU law should be assigned the status of primary legislation. The committee acknowledges that this would have a number of constitutional costs. For instance, it would mean that retained EU law could not be struck down under the Human Rights Act, and it would also be immune from judicial review under common law powers. But the committee believes that the constitutional gains will outweigh the costs because it will ensure clarity and certainty and would be consistent with the doctrine of parliamentary sovereignty. There have also been a number of other suggested amendments to the bill, including inserting protections for public health and the environment, and ensuring that the Belfast Agreement is upheld and that there's no reintroduction of a hard border between the Republic of Ireland and Northern Ireland. We shall see whether any of these amendments survive. There have also been a few Brexit-related cases making their way through the courts recently, although none as interesting or important as the Miller case. James Eadie and I have recently been engaged by the government to defend a judicial review challenge to the government's refusal to publish unedited versions of so-called Brexit impact analyses published by the Treasury and the Department for Exiting the European Union. This was quite a bold challenge because the claimants relied on common law powers of disclosure, even though there is a statutory regime for dealing with requests for information held by public authorities under the Freedom of Information Act. The government therefore sought to knock out the claim at the permission stage on the basis that there was a suitable alternative remedy available. The court agreed and refused permission, but the claimants have renewed their application and it's due to be heard at the beginning of March. But I think the challenge is likely to be overtaken by events because, as you may know, the government has been placed under pressure by the House of Commons Select Committee to publish non-confidential versions of these reports. And in any event, there have been a number of recent leaks to the press of reports that suggest that the UK will be financially worse off under all possible Brexit scenarios. In terms of political developments, the Conservative government is currently tying itself in knots trying to determine its negotiating strategy with the EU, both in relation to the transitional period after exit and in relation to the ongoing future relationship with the EU. Currently, the Cabinet is bitterly divided between hard and soft Brexiteers, with one wing arguing that Britain's relationship with the EU should involve only modest change after Brexit, and that the UK should try and remain within the single market and customs union, with the other wing arguing that there should be a hard Brexit where Britain strikes out alone. All of this is placing immense pressure on Theresa May to make the government's position clear. Her inability to control her ministers and to provide a clear direction of travel is weakening her hold on power. But although there are daily rumblings in the press about a challenge to her leadership, there doesn't seem to be a viable alternative for Prime Minister at the moment. And in the meantime, time is running out because negotiations on the transitional phase begin this week. So what does all of this mean for New Zealand? More trade, of course. Hopefully, New Zealand will be the first in line to do a trade deal with the UK, and after that, no doubt, the UK will be coming after the New Zealand trade negotiators to come and work for them. Farewell.